Welcome to Behind the Scenes. I'm your host, Hector Montalvo. This show is dedicated to bringing you tough questions and their responses. I'd like to welcome my guest today, Attorney Tom Mixon, and also Attorney Stephen Wright. We will be discussing today harassment versus restraining orders. Mr. Nixon?
Thank you. Nice
Mr. Wright, welcome. Again. Thank you for attending. Mr. Mixon, can you tell us what is harassment? What is considered harassment?
The new statute that was passed recently and enacted here in the Commonwealth allows for really any individuals who feel that they've been harassed to obtain a restraining order, similar to the older 209As. The difference being that that doesn't have to be the relationship before. If you were going to, in the past, seek a order of protection, there had to be some sort of relationship, either a family relationship, a dating relationship, something along those lines. The change in the statute specifically was to allow non-related individuals to get this order, and it's a much broader order of protection than I think the 209As were.
So do you see many of these cases coming to light now?
Well, it is a fairly new statute, and what is another change that I think is going to lead to more of these types of orders is that it's going to be allowed in all the courts, the juvenile courts, the district courts as well, superior and probates. I mean, those always had that type of jurisdiction for the 209As, but now with the with the harassment across the board, so to say, I mean, you're seeing school children come in, and it's kind of dovetailing on the heels of the so-called bullying statute. If you've had a chance to look through that, that doesn't provide really any sort of protection. That's just telling the schools what they have to do. So I think this is how you're going to see the harassment statute being used.
Mr. Wright, what is your opinion in regards to the new harassment law?
Well, I've had one actual experience with it, and it was a situation that I think was not handled properly. Obviously, I'm not going to get into exact specifics, but some of the specifics of the events and the evidence that we went into in responding to the original restraining order, which was obtained by a lady ex parte in front of a judge, and then my client had to respond. He hired me to respond, and as we got into the facts of the matter, my feeling was that there were a couple things dovetailed the ability of justice to be served here. One of them was the first judge who issued the order was not the judge who came back to hear the response. So the second judge was faced to, if our position was to be believed, to overturn the first judge's finding. And you don't see judges in the district court areas doing that very often unless there's really compelling evidence. And I thought our case was very close to compelling, but the judge, in my case, extended it for half the period. So it had some effect, but in truth, I don't think that justice was served really in the one case that I have been involved in. And that's the only one that I have seen. Of course, the statute is very new. It did not go into effect, I think, until May, I believe, after being enacted in February. So I haven't seen a lot of it. I don't think you're going to see an awful lot of lawyers involved in it, possibly representing respondents. But again, as Mr. Mixon said, I think it's a response to the bullying statute, trying to put some teeth into something that can be enforced. And in extreme measures, I'm sure it's good and called for. In the long run, I think that it's going to be a situation where it's going to be very hard for accused people, who will be, in all probability, males in most instances, to get justice if they really do have a defense.
It's interesting that you mentioned that it affects mainly males. But what you mentioned, ex parte order. Can you elaborate what is ex parte order?
There's actually two ways to get the ex parte order. One, you can even go to the on-call judge. So if it's after court hours, they can telephone the police station. There's a whole form. I did bring that with me, and maybe if we have some time later, we can go through it to see what the actual elements are, because there's a variety of ways in which you can, seek the protection, some more complicated than others. So the ex parte would be the on-call judge, or if you just went before the court, filled out the application, the other party wasn't notified, and you just went in and filled out the affidavit and said, this is the type of harassment I've been exposed to, and then the judge could either issue the order or he could set it up for a hearing. Either way, they'll set it up for a hearing.
So an ex parte is basically one person making an accusation to the actual court. The court listens to that particular accusation and makes a determination. What about due process and equal protection? Does that...
Well, that would come in at the hearing stage. Then you'd have a right, you'd have to be served the order, obviously, and you'd come in, and then you'd have your right to say why the petition shouldn't issue.
And and in the beginning stages of a restraining order, I'm assuming it's a civil penalty? It's a
civil
restraining
order.
It's a civil order, okay. Does it have any implications, criminal?
Certainly.
On it?
It's like the restraining order. When you violate it, then it becomes a criminal matter, and that's when I think you'll see more lawyers getting involved in it, because it's so new. I'm not sure if there's any violations yet that I'm aware. I know there are orders that have been issued, but if you use the analogy to the restraining order, I mean, you get the restraining order if you abide by it. Of course, it's not a criminal matter until you either contact the plaintiff or you abuse him or her in some way.
So a restraining order differs from a harassment order in the sense that a restraining order under 209A is basically domestic relations, right, and the harassment order is basically under a 265E chapter or something along those lines in regards to any individual person. So on a harassment, who can harass who? I mean, is there any type of harassment what's considered harassment for anyone?
Well, let me just go then over a little bit of what they ask you for. It would depend. There's a couple of categories. First that they're looking to would be people under 18 and 17 or 16 or younger. So there's they break it up right there. But then there's three different ways upon which the harassment under this statute can go, and one is, I'll do the first two more easy. On about a certain date, the defendant by force, threat, or duress caused me to involuntarily engage in sexual relations. So that right there would be harassment. You wouldn't need anything other than that.
Okay.
I mean, some of these are also crimes too. So, and then there's the same thing. On about a certain date, the defendant committed an act against a person that constitutes a violation of any of the following statutes: indecent assault and battery, rape, statutory rape, assault with intent to rape, enticing a child, criminal stalking, criminal harassment, or drugging for sexual intercourse. Those are the more, I guess, clearly defined reasons that one could seek an order of harassment. The more problematic, and the one I think you're going to hear a lot about, is when you don't have any of these alleged crimes of being forced into engage in sexual relations, but you say that the defendant, meaning the person you want the protection from, committed 3 or more acts of willful and malicious conduct aimed at me, which were committed with the intent to cause fear, intimidation, abuse, or damage to property, and did in fact cause fear, intimidation, abuse, or damage to property. Now that is going to open the Pandora's box, so to say, and I think that's where you're going to see the need for some litigation.
That was the element of the case that I was involved with. In this particular case, the offended person or the plaintiff went before a judge ex parte, and she had first filled out an affidavit, and what she said in her affidavit essentially was that on at least 5 occasions this man threatened me, put me in fear, words to that effect, never alleging any kind of touching or anything like that, and then gives dates of particular months running back for 5 years. There's no way that the defendant could really respond to that. I mean, here it was. She also said that he had a problem mixing alcohol and his medication, and she also said that he had threatened her. Now, when we put our case together, his doctor gave me an affidavit. Now, you can't bring a doctor to one of these hearings. We have an affidavit from a doctor, which the court accepted, saying that he did not have any problem with alcohol and mixing any of his medications. It simply did not exist. And the other thing was, we brought in a police report which had showed that the week before this woman took out her complaint, my client had been attacked and struck by her boyfriend, and he had reported it to the police, and the perpetrator admitted that he had done it to the police officer. And my client had the option, I suppose, at that time, of going to get a complaint for assault and battery. He wasn't really badly hurt. And we brought that police report in with evidence, along with the doctor's report. And again, I tried to make reference to it. I said, you've got 5 different years, 5 different events, none dated specifically, just by month, and just general statements. I said, this should not be enough. And what the judge said on top of the affidavit was that this lady said that I had to watch my back because this guy was going to do this. Well, I mean, in this instance, I had known this client for more than 20 years. He had no criminal record. He had never been other than speeding tickets. He'd never been in court before. And and he was a practicing Mason in the town. It's a small town. And I just feel that he was victimized because of first of all, the judge allowing the victim to pick out 5 different months of 5 different years without any specific dates. So we didn't have any opportunity to alibi them if there was an alibi. And then the judge elicited from her, she told me to watch my back, etc. And, we pretty well refuted her veracity, and still we failed to prevail. And I just keep coming away with the sense that it was unfair, not because the judges themselves meant to be unfair, but I think the situation that my client was placed in, despite our efforts, failed. And I think justice was to some extent miscarried in that instance.
Now, some restraining orders, you'll hear a lot on the street that a lot of restraining orders are obtained fraudulently, false accusations and so on. How does one prove false accusations against?
You've got to do it. That's what you've got to do. The problem is that it also decides the custody issue in any contested divorce case if the restraining order issues. I mean, it has a tremendous impact.
Correct.
I have been successful in fighting some, but you've got to really have your facts there, and you almost need a third witness to refute the complainant, because the judge is going to err to the conservative, and must, based on some past history that we all know about. And I can't fault the judge for doing that, but I do say that they've got to be compelling in getting dates and times so that possibly, if there is a refutation or a situation where the defendant was somewhere else at the time, at least he can show it.
Correct.
And with no specificity, I just kind of felt my client was trapped, even though I felt going forward we had enough to beat her credibility based on those events. But as I said, I have kind of a sour feeling about it.
So the police department has a tough task in hand when they have to go out and issue these serve these restraining orders on any defendant or any individual. Is that something that the police department do on a civil matter, where the police department usually handle criminal cases? Who's responsible to have a civil order served upon a defendant?
Yeah, they're going to have to
They do it
serve
anyway.
like the restraining order.
On the actual individual. Now, what if someone did not know that there was a restraining order? How does that affect that individual?
Well, it would come up if there was an alleged violation, of course, notice. And it doesn't have to technically be served either in hand or by mail if the person has notice, either by phone or by some other mechanism. They can be held to have sufficient notice, and obviously they would have to adhere to the terms and conditions of the restraining order.
No, that's a call the court would make. So he had notice. He had to be here, or he had to respond. In the case with my client, they left. The local police came over and served them in hand.
They did. So, we see about Massachusetts issues about 25 to 50,000 restraining orders a year, just in Massachusetts. You mentioned that some of the orders are a tool to affect children in custody cases. Can you explain a little bit more about that? How one benefits and how the children benefit from a restraining order being, say you can't see your father for a couple of days, you can't see your mother for a particular amount of time. What type of effects does that do to the children?
I think, if I may, that what I was trying to say was, you have a situation where the parties are split up, they're going to get divorced. An unscrupulous mother, if she feels there's going to be a custody battle, can create enough emotion to walk in and get a restraining order under 209A.
Which is totally different from the harassment prevention orders, correct?
Well, some of the tests are the same.
Okay.
But you don't need the 3 times.
You don't need the 3
times. You can have a single
right.
incident, and you can get your restraining order, get the other parent out of the house.
Move the party out of the house. And
so once the court issues that order, now they move the party that the accusation was made against. They remove automatically from the house. I've read that they have to surrender their firearms if they are a licensed firearm carrier.
Yeah.
Doesn't that violate someone's due process and the right to equal protection, the right to face their accuser in a court before these actual orders are issued?
Well, if they're issued ex parte, because most of the restraining orders are issued ex parte. The one party will go in, they'll apply for a restraining order, and the other person isn't there. Although sometimes, especially if there's a pending criminal case, the other party may be there, and then you could have the hearing right then. So, and there's also provision, though. If you are ordered to surrender your ammunition and your guns and any other weapons you have, you can go into court to try to get it back, especially if there's been police officers that I've seen that have had restraining orders issued against them, security guards, people that need their weapons to be able to, have their job. So that you get that at the so-called 10-day hearing.
So we do actually see a whole bunch of abuse in restraining orders. Have you guys seen the restraining orders being abused?
Oh, sure.
Absolutely.
In the system. What do you think needs to be changed in the restraining order aspect so people are held more accountable versus, because I know there's perjury charges if you can prove that someone has committed or obtained a restraining order fraudulently, because these restraining orders are signed under the pains and penalties of perjury.
And everything in the district.
I've never seen a perjury on something like this. I don't know if you have, counsel.
So if it's proven, you're saying that because it's signed under the pains and penalties of perjury, and I'm assuming that perjury in the state of Massachusetts carry maybe a 20-year sentence for perjury. I could be wrong, but
I think it's only 5. But
I've
never seen anyone prosecuted for lying on a restraining order.
No.
And sometimes it's pretty blatant. But I think the problem, Hector, is, and obviously, in a large amount of cases, the restraining orders are necessary to prevent abuse. But there is a number out there that, as you say, gained fraudulently. I think the judicial has to look more closely to these instead of giving them out like candy. I mean, you can't just read the affidavit and give it and come back in a 10-day hearing and automatically extend them. I think, if there is going to be a contested restraining order, both parties are going to have a right to be heard, present their defenses, because the ramifications to these restraining orders are severe.
Yeah, I noticed that in looking at one of those restraining orders today, I noticed that there is a checkbox on one of those restraining order forms in the 209A section that allows an individual person to say, I want my children not to have any contact with that defendant. I mean, should that be removed? Maybe that will stop some of the abuse as far as using children as a tool?
Well, the problem is, if the children are going to continue to reside with the person who sought the protection, how can let's just say the husband is ordered out of the home, how can he come back and have a meaningful relationship in the home with his children? So in those types of cases, I think your best bet is to go to the probate and family court, where they're more specialized, I guess, in dealing with these types of issues, rather than the district court that really doesn't want to get involved in custody and support issues.
Now, you mentioned the legislature, the judiciary branch of government. So the judiciary branch is the power that creates these laws at the State House?
Well, no, that would be the legislation.
Okay.
And I think, the intent, the legislative intent on, the harassment and even the restraining orders is great, but it's when, you get into the practice and people use it to their advantage.
So they'll use it to gain custody, advantage in custody. They'll also try to use it to gain public housing, public assistance type of deal, and so on. So basically, there could be a chance that these restraining orders are actually costing taxpayers a lot more money than they're actually helping individuals, would you say?
It'd be hard to give an opinion without seeing the monetary effects. I mean, let me be a bit redundant. I think when you do come in on a restraining order in the district court, you should see the same judge who originally issued it, thereby not putting a pressure on a second judge to reverse the first judge's order. The other thing, I know I'm being redundant, but specificity as to when it happened, where it happened, what time it happened. I think a judge has got to say that, not say, it happened to me 6 or 7 times back in 2005 and once in 2007 without, it's just unfair.
So under the harassment prevention order, if it takes 3 claims of an act, how does one prove those acts? Who's in a civil restraining order, anyone can go in to get a restraining order. I'm assuming that harassment would have to be issued through the police department?
No. Well, 2 ways. Again, if it's after court hours, you go to the police station, and then you're connected to the judge who's on call. And they do it over the phone. So even though you're at the police station, you are talking to a judge. Or you go into court and during normal business hours and you fill out the application.
Should there be a little bit more training as far as judges are concerned? I like to see if the restraining order is a civil matter and the criminal section has the criminal court, I think there's like 7 different branches within in the State House. Wouldn't it be feasible because it's a civil order that holds criminal implication, wouldn't it be better to take it away from the civil side of the court system and keep it all in the judiciary branch and the criminal side of it?
That's a hard question to answer. What I'm thinking is that you're going to go, let's say it's going to be a woman, is going to go in ex parte in front of a judge, having made an affidavit, and is going to make a statement. And the preponderance of the evidence is what you're looking at there. In criminal, you're saying beyond a reasonable doubt. And supposedly that gives you a protection on a violation. But as far as, again, the court being constrained to err to the conservative, it's going to continue to do that. And I don't think you're not going to train judges. I mean, every judge has got his style and his manner and his philosophies. But you can't do that and train judges. Point being, you can ask, give us more specificity to to determine whether or not this really took place, or give the defendant a chance to at least know when.
Or enforce the laws that you were sworn to uphold, basically. Because the Constitution states one thing, and then the laws, they have to follow both. And if they're issuing these orders and denying due process and equal protection and affecting children and family and so on, my understanding on these restraining orders, once these restraining orders are issued, and you can correct me if I'm right or wrong, they go into a database system. Now, once it's in that database system, does it ever come off that database system?
It can be withdrawn.
But I think it would still
could be
stay
vacated.
be there.
What about expungement?
There is a process to expunge. It's done not very often, no. I mean, you need a very valid reason that this whole, I guess, process was fabricated, something along those lines. Short of that, you're going to be in the database system, and
so you will be
in
the database, and that will affect employment. It will affect.
It can certainly affect employment. Especially, I know, police officers who have restraining orders issued against them. They're put on administrative duty. So their weapons are taken unless they're able to convince the judge that they need their weapons back. So it creates a hardship for a lot of people. And the children, too.
And this is part one of a series of part two on the harassment prevention order and the abuse prevention order. We're running out of time on the first part one. Mr. Mixon, why don't you give us a minute or so of your information, so how people can reach you and get a hold of you if they need some legal advice?
My law office is located at 630 Boston Road in the town of Billerica. My phone number is 978-667-2300. And I practice a lot in the district and juvenile courts, where I think a lot of this new harassment statute is going to take place.
And
Mr. Wright, would you mind giving out your contact information for those
Yes,
viewers?
my name is Stephen White, spelled Stephenwight. My law offices are at 130 Parker Street in Lawrence. That's right on Route 114 in South Lawrence. My phone number is 978-685-2400. I'm licensed in both Massachusetts and New Hampshire. We do a lot of marital, along with civil, along with criminal, and essentially that's it.
Well, and I appreciate that. And you have been watching Behind the Scenes. I am your host, Hector Montalvo. Join us next week for part two as we bring you more of the tough questions and you decide.